What are the legal issues surrounding water privatization? Water privatization is a hot topic that raises many questions. When water supply and management shift from public entities to private companies, several legal issues come into play. Let's break down these concerns in a straightforward way. First, property rights and ownership are at the forefront. It is essential to define and enforce who owns the water resources. In a privatized system, private owners need clear rights to manage and invest in water effectively. Without these rights, disputes can arise over usage and access. Libertarian principles stress that strong property rights are vital for efficient resource management. Next, we have the authority to privatize and contractual law. Public entities must have the legal power to enter contracts with private companies for water services. This authority can differ by location and often requires specific laws or regulations. Contracts should outline service standards, pricing, duration, and penalties for not meeting these terms. Legal challenges can emerge regarding the scope and enforceability of these contracts. Regulation and oversight are also critical. Water is a vital public good, so governments usually impose regulations to protect public health and ensure water quality. Legal issues can arise around how much regulation is necessary, balancing the freedom of private enterprise with the public's interest. Libertarians often argue for minimal regulation, believing that market mechanisms and property rights can lead to better efficiency. Accountability and liability shift when privatization occurs. Responsibility for service failures or contamination falls on private operators. Legal frameworks must establish rules to hold these companies accountable for any harm or negligence. From a libertarian viewpoint, private ownership increases accountability since owners face direct financial consequences. Access to water raises human rights considerations. Some argue that water should be treated as a human right rather than a commodity. Critics of privatization worry it may limit access for low-income populations. Libertarians typically see water as an economic good best managed through voluntary exchange and private contracts. They believe that well-defined property rights and competitive markets can improve access and quality. Finally, the transition from public to private management can lead to legal challenges. This includes employee rights, valuing public assets, and ensuring service continuity. Laws may require public consultation or impose conditions to protect consumers and the environment. In practice, libertarianism supports water privatization as a way to enhance economic freedom. It aims to reduce bureaucratic inefficiencies and improve service quality through competition and clear property rights. Legal frameworks that align with libertarian views prioritize strong contracts, minimal but effective regulation, and clear ownership rights to encourage innovation and accountability in water management.